I want to see justice and pieces, okay?
Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And today's guest is joining us from, I guess, in Toronto here, but Alexi Wood, and she's going to talk to us today about the case of Bent and Platnick, amongst a number of other things. So thank you so much, Alexi, for joining us here today.
Thank you for having me.
Perfect. So maybe we can start before we get into the case there. I know a lot of the mooters who are going to be listening to this will want to know a little bit more so they can prepare. But perhaps maybe you can start and tell us a little bit about your practice. And I know you have a very interesting history getting to that point. And maybe you can tell us what led you to what you're doing now.
Yeah, absolutely. So my practice is I practice at my own firm. It's called St. Lawrence Barristers. I founded the firm in 2017, and we have a mix of civil litigation. We do some harassment and privacy, defamation work, some media law work. We do some charter work as well. I also have a health law practice. And we have a practice of public law, doing administrative work, various judicial reviews and that kind of thing. So a broad civil litigation practice.
Yeah, and maybe you can tell us a little bit. I know obviously every day for a lawyer is different, but sort of what are the different things that you do? And especially for all the students that are listening about if they're in kind of a very general sort of litigation practice, what are the sort of different areas they can get involved with? Obviously no two places are alike as well, but maybe you can share a little bit more.
Absolutely. So my one of the things I love about my job is that my days are always very different. I really don't have 2 days that look alike, which is something that I really enjoy because I never get a chance to get bored. But in general, my work is, if I'm working towards a court appearance, we'll have written materials. We'll be doing legal research. We'll be drafting our materials, whether they're the affidavits or the written arguments. So we'll be spending time on that. I do opinion work for my clients as well. So they might come to me and say, I have this legal issue. What are my options? So we'll have to research what the options are and then give them our legal opinion on what they might want to do. I spend time, working through legal issues with my clients if they've sought my advice on things. And for civil litigators don't tend to be in court as much as criminal litigators. So criminal lawyers are definitely in court a lot more than civil litigators, but there are certain parts of practice where you are in court, or at least doing some kind of advocacy. So for civil litigation, we might be doing examinations for discovery, which are an early phase of litigation where you're finding out all the facts, but you're questioning witnesses. So we might be doing something like that. We might be in a mediation. But each of those steps has an advocacy piece of it that is certainly, it's not necessarily being in court, but there's an advocacy component to it. And then my practice does involve being in court a fair bit for civil litigators. And we do consider ourselves to be courtroom lawyers and trial lawyers, which is a fun part of my practice. And I certainly enjoy the courtroom aspect of my practice.
Now, certainly you touched on obviously, in court with litigation as well. I know you do some work in professional regulations, and there's kind of a difference, obviously. Between the different tribunals, and then being in, let's say, superior court. And maybe you can outline for students kind of the similarities and differences there from representing, let's say, either the defendant in a matter at the superior court versus representing someone who, there's an allegation of maybe like professional misconduct or some kind of disciplinary action.
Sure. So I do a fair bit of disciplinary work, particularly for regulated health professionals. I have some other regulatory and administrative work that I do, but largely my professional discipline work is for members of regulated health professionals. So I'm dealing with the health colleges, and the work that I do with the health colleges has a lot of similarities to work that I would do in superior court. And it's one of the things that I really enjoy about the regulatory work is that it is very similar to being in superior court. The rules are quite similar. The steps may be different. So in a regulated matter, we wouldn't necessarily have the discovery phase like we would have in superior court. But other than that, we provide a response to the complaint, which is very much like a defense. There might be a period of time when we can negotiate with the prosecution, which is much like trying to settle a civil matter or going through mediation. Oftentimes you need experts, which you would need in superior court for depending on your file. And then if you have to go to a hearing and you go to a hearing, the hearing is very much like a trial, except one of the biggest things in being in a regulated setting, in a tribunal setting like that, is the people making the decision aren't necessarily going to be lawyers. So all judges are lawyers, but the people making the decision at a health college, for example, aren't lawyers. They are health professionals or members of the public. And then there'll be another party at those tribunal hearings, which is an independent legal counsel. And independent legal counsel provides legal advice to the tribunal to say, so for example, on what the rules of evidence would be if there was an objection or something like that. So in a superior court, if there's an objection, the judge rules on it. But in a tribunal setting, independent legal counsel would give the tribunal their legal opinion on a situation, so then the tribunal can make the decision based on counsel's advice. But otherwise, they're really quite similar. I actually really find the regulated tribunal matters really interesting. I enjoy them a lot. The stakes are obviously very high because you've got someone whose professional license is on the line. It's one thing to have to pay an amount of money, but if you tell someone that their professional livelihood is at stake, that's a really big deal. And so the stakes are quite high in a regulated matter. And I really enjoy working and doing the work for those members at the tribunals.
And do you find that the members there are kind of more involved, kind of like, I think, for those who've studied, the inquisitorial versus kind of more of an adversarial approach, or do you find it's very similar in that regard to a justice at the superior court that kind of let the counsel kind of play things off each other there?
You mean at the hearing itself?
Yeah, at the hearing itself, like in terms of, when questioning is done in cross-examination, that they would kind of pipe in there with questions of their own, or do you find them kind of being more hands-off, just like in courts?
No, it's very similar to a court process in terms of the witness questioning, in direct, in cross, all of that is very similar to what you would have in superior court.
Okay, perfect. So I think before I forget, and then we run out of time, let's, a lot of the people here are going to be competing, or people listening later will be competing in a mooting competition with a case that you are very familiar with, as you represented one of the intervening parties. So the case of Bent and Platnick. So perhaps maybe you can tell us a little bit, maybe just very quickly, about what the case was about and kind of who you represented, and what are some of the submissions, and what was kind of the result in the end there.
Sure. So Platnick and Bent, as I'm sure the people listening to this will know, dealt with an issue of a lawyer who made some comments about an expert. But she made those comments in the context of what was supposed to be a confidential chat room or chat group for a lawyers association. She was a member of this lawyers association. There was a discussion about an expert, and she provided her opinion. It was an unfavorable opinion about an expert. That her comments were made public, which was against the terms of use of that chat group, but her comments were made available to the general public, to the legal community. And when the expert got wind of the fact that she'd made these statements about him, he sued her for defamation. She then brought a motion to dismiss the matter under the section 137.1 of the Courts of Justice Act, which is known as the anti-SLAPP provision, SLAPP being strategic litigation against public participation. That term isn't actually used in the legislation anywhere, but that's what it's colloquially called, and that's what people sort of know it as. But that term isn't actually used in the Ontario legislation. It's used in some other provinces, but not in Ontario. So that case and a companion case called Points Protection went up to the Supreme Court of Canada. And when they were at the Supreme Court of Canada, my firm represented the Canadian Civil Liberties Association, who intervened in that case. There were many interveners that showed up at the Supreme Court, CCLA being one of them. And CCLA argued three main points, but two really strong points that are important to talk about here. One was on the term public interest. And the term public interest appears repeatedly throughout section 131.7, 137.1, sorry. But public interest isn't actually defined in the legislation. The legislature just used the term and then didn't define it. So CCLA intervened, and one of the comments that they made was that the court needed to clarify what it meant by public interest. And the CCLA said that public interest needs to be defined broadly, but it needs to also afford a certain amount of privacy protection. So individuals are entitled to some amount of privacy protection. And as the Supreme Court said in Grant v. Torstar, public interest isn't necessarily synonymous with what interests the public. So there might be a public interest in the sense that members of the public are interested in something, but that doesn't necessarily make it public interest in the legal sense. We have to be aware that there might be some sort of personal privacy protections that come into play. So that was the first submission from the Canadian Civil Liberties Association. The second was about the quality of language. So at the Ontario Court of Appeal, their judgment had said that when it comes to the balancing, which is the secondary prong of the test, so under section 137.1 sub 4, when the motions judge gets into some balancing, at that point, the Ontario Court of Appeal had made a comment that the court could weigh the quality of the expression, including things like saying that if the speech was vulgar or intemperate or shouted, it might be less worthy of protection. And the Canadian Civil Liberties Association disagreed with that and strongly suggested to the Supreme Court that any sort of weighing of the quality of the expression was a dangerous position to be taking, because just because speech is, somebody swears or somebody's yelling or somebody isn't necessarily as eloquent as somebody else doesn't mean that their complaint or their submission or their expression is less deserving of protection. You shouldn't have to be an eloquent orator in order to be able to get court protection for your expression. And that if that part of the test that was advanced by the Ontario Court of Appeal gets picked up, it kind of leads to this position where courts and judges are going to weigh expression and say, I like this expression better than that expression. And this one is more eloquently said than this one. So that person just yelled it and they were being profane when they said it. And that's a dangerous place in the CCLA's submission to get into. So we wanted to try to get the court to say that, you shouldn't be looking at the quality of the expression in order to decide whether it's deserving of protection or not.
I guess maybe just to clarify that, then would that kind of lead to, well, because you express, let's say, about this, let's use the example there, this expert in a more eloquent kind of polite way, then it wouldn't amount to, it would be treated differently than if you said, well, that bleeping bleep expert,
exactly.
Then one would be protected and the other, and then who's assessing the quality of the language, so to speak, right?
Exactly. And you can think of it in terms of slogans. Slogans are often meant to be short, attention grabbing. You put signs on, words on a sign. They might have, somebody might swear in them. And just because somebody's been swearing when they wrote something out on a sign doesn't mean that they don't have a valid position to protect. We think of social media. If it's on Twitter and it's in 128 characters, you're going to have to find some way to make it really punchy. And as opposed to writing a dissertation on the topic. So you might be more inclined to be attention grabbing and say something profane or shout it or do something like that. And that doesn't make it any less valuable expression than somebody who wrote an eloquent dissertation on it.
And so what ended up happening then at the Supreme Court? I know the decision came out almost like a year ago now, but what did they ended up saying? Kind of maybe you can focus on those points that you raised on behalf of the interveners there, but what ended up being the result of the Supreme Court?
So the Supreme Court's decision was very much, they really said that what we needed to do is focus on the legislation. So their decision is very, it's really a statutory interpretation decision, in my view. The court went through and said, here's what these parts of the legislation mean. So from that perspective, there is some guidance for lawyers who are now going to be arguing anti-SLAPP motions, because the court really did go through the legislation. The court picked up a bit on the idea of quality of the expression, and they did say that it needs to be careful in terms of what is said in terms of weighing the expression. The quality of the expression is not necessarily something that will weigh in the balance section of this. And then in terms of public interest, they reaffirmed Grant and Torstar, and they said that that is still the test that is used when it comes to public interest. So they did provide some guidance in those areas, in particular, like I said, in terms of the statutory interpretation aspect of it.
Perfect. Now, I think maybe along sort of the lines there, I mean, for those mooting, some of them may be experienced with mock trial, some of them may have never done a moot. And maybe you can kind of share, obviously, because we're going to try to replicate an experience, where you get before, a few judges there, and eventually when they think they get to like the final rounds, there's like, a full panel of people there. Now, what it's like, first of all, going in and speaking before the Supreme Court, and kind of how do you deal with the nerves that, a lot of these students are going to have, or maybe all of them are going to have when they're facing sort of the questions that come up. So maybe let's start from preparation itself, right? How do you prepare when you're going in now as counsel for an intervening party, or supposedly it could be also for the applicant or for the appellants or the respondents as well.
Mm-hmm.
And you look at the decision. So here, let's say the Supreme Court decision is going to be appealed to a fictitious higher court, but looking at the Court of Appeal, like you mentioned, and you said, hey, here's this part here about quality. How do you prepare then if you're going to go and represent again, the intervener or an appellant or respondent, of getting ready for making submissions there before the Supreme Court?
Absolutely. So I'm sure all of the students have heard repeatedly that preparation is a huge part of any court submission. And it absolutely is, and it's not even just court submissions, examinations for discovery, mediation, anything, they all require a huge amount of preparation. And it's absolutely true. So for me, for preparing for oral arguments, I do write out my oral submissions. I don't write them out fully in paragraph sentences, because my style, and everybody's style is different, but my style is much more conversational. And so if I write something out, I don't want to be standing there reading it. I do point form, because then when I write them out, I have them in big, huge font so that I can just look down at it briefly and then look back up again. Because in my opinion, eye contact and staying engaged with the bench is huge and important. So you don't want to be face down in your notes the entire time just reading. And I worry that if I've written it out in full sentences, I'm going to be staring at it reading. So I do point form so I can look down quickly. Right, that was the point I wanted to make. Look back up at the bench and engage with the bench. So I do that. And as I said, I write it out fully. I write out every point that I want to make. I make sure that I have under each point, I then have a secondary point where I have the source for it, the tab in my materials, or the page reference where the judge can find my source for it. So if it's a source, a fact source, it's to the record. If it's a case, it's to the book of authorities. But I have the page number where the judge can turn to find that. As I said, I will write it all out, because some judges will let you get through your entire submission and will let you talk. So I want to make sure I have everything written out in case the judge lets me talk. But not all judges let you talk. Some judges will interrupt and will ask questions. And if it's an important case, so for example, a Supreme Court of Canada or Court of Appeal decision, and even sometimes for Superior Court, if it's a big motion, I'll do this as well. I impose mercilessly on my friends and make them act as judges, and I moot my submissions. And I have done that for every Supreme Court case that I've done. And I do that for, even as I said, even for some Superior Court motions, I will make my colleagues or my friends sit and listen to me and pepper me with questions, because it's only in answering those questions that you will start to become comfortable with it. And sometimes, and many times, my friends have asked me questions and my colleagues have asked me questions that I didn't anticipate. And I think, oh, shoot, I don't have an answer to that. I better figure out what my answer is for that one. And okay, I'm going to make a note of that. And then I go back and I figure out an answer. And then in my, if whether I'm doing it, I have recently started doing it with COVID, everything's all electronic. So my submissions are now on a tablet as opposed to being in my binder. But whether it's in a binder or on a tablet, I will write out, I will think of questions that I might get from the bench. I will write that question and then a few points as an answer. And then I tab those in my submission so that I can flip to it if I need to, particularly for the reference points. And then because I might get interrupted, I also tab my submissions with the topics in my submissions. So if I've gotten interrupted, and this is particularly when you're at the Court of Appeal or the Supreme Court where you're timed, and for a moot where you'd be timed as well. If you get interrupted and the judge has taken you off track, but it's something the judge really wants to know, then you got to keep going with the judge. But then if you've got a few minutes left at the end, you can just look through the tabs. Okay, these are the key points. I've really made these 5 points, but I haven't made these 3. Out of those last 3, this is the one that's the most important. Okay, I'm going to go to that last one, make my submissions on that last point, and then that's my time. So there's a time management aspect that definitely comes into oral submissions as well.
And do you find, I mean, I know certainly with mooting where you have very, very short times, sometimes I see students are getting tripped up on kind of weaving between answering that question and then kind of what they had prepared, or there's like a noticeable difference. Like, they're delivering something that they've probably practiced over and over again. And then suddenly you get this question that, like you mentioned, from some of your friends and colleagues that you weren't expecting, which, one thing that happens when your colleagues are asking you, well, what happens when, one of the Supreme Court justices asks you something and you're like, oh no, I don't know, even all that preparation. What do you do? Like, how do you kind of address that question? Or maybe if you're like completely lost, have you ever had a situation, and what did you do to kind of answer the question there?
I am sure there has been a situation where I have been completely taken off guard by a question. It's not coming to my mind immediately now, but I'm sure that's happened to me. I actually really love questions. It's one of my favorite parts. I actually get more nervous making submissions when I'm just reading my submissions. And my strength is in answering questions. So I have not had a problem. I can't think of something immediately off the top of my head where I've been totally stumped at a question, because and I do credit my preparation for a lot of that, but it's also just my comfort level. I'm really comfortable answering questions. There's actually one of my first appearances at the Supreme Court where I was speaking was an intervention several years ago on the sharp private use exception. And I was making the submissions and the justices weren't asking me any questions. And I was just reading my submissions. And I actually started tripping on my words because I started thinking in my head, oh, they're hating this. They're hating my submissions. They're hating what I'm saying. They're not engaged. They're not answering us. They're not asking me any questions. This is going over terribly. This is awful. And I started psyching myself out and tripping on my words because I was so nervous that my submissions weren't going in well because nobody was asking me any questions. And then finally, Justice Rothstein asked me a question. And I because the Supreme Court is recorded, I have gone back to watch it. And I actually just like go, thank you, Justice Rothstein. And I launched into my answer. And as soon as Justice Rothstein asked me that question, I calmed right down and my submissions got much more clear because I was so nervous because I wasn't getting questions. So for me, when I'm answering questions, I will, because I do practice it a lot as well. I do know what my key points are. And so when I'm answering a question, I think it's very important to answer the question. Judges are very smart. And if you try to sidestep their question and give them an answer that's not fully responsive, they're just going to get annoyed with you and they're going to pin you down. And so I think it's very important to actually answer their question. But then in the course of answering their question, if it takes you in a sort of sideways way to get back to one of your main points, I think that that's absolutely appropriate to then work back into one of your main points. But you can also just have the break and say, okay, I'm going to answer that question and answer the question and then step back into your submissions. I also personally am not a fan of saying to the judges, I'll come to that later. If the judge is asking a question, it means that that's on their mind. And I personally would happy to answer that for you now, Justice. And then just launch into that question, even if it's something that you had planned on answering later. I worry if I don't, that the judge isn't going to be paying attention to my submissions until I actually get to that point, because they clearly want to know that issue.
Well, that's great. I think it's interesting because usually it's the opposite, right? People are, if I don't get any questions, I'm doing amazing, and then suddenly I get this question, and then I'm pausing and stammering and trying to figure out what to say. Maybe you could share then. I mean, certainly preparation there, and everyone I always talk to, I think that word comes up, over and over again: preparation, and as well as the lawyerly "it depends" answer. But what can you share then in terms of preparing with people, asking you questions, doing like little rapid fire to get that confidence that you have with questions from the bench? What do you think students can do to better equip themselves? And very well, it might just be make sure you are prepared to get to that point where you're very comfortable and you're not sweating buckets there, afraid of what the next question is going to be. So
I think, I do think that trial runs are really important. So, for students that are doing a mock trial or a moot court, that they do trial runs. And I know I've coached some teams for law schools that we often do trial runs with, other lawyers, with law firms, that sort of thing. So I think the trial runs are really important. And I think it does just come with familiarity of the material. And you go back through the cases, make sure you know the cases, make sure you know the record, make sure you know all of that. And I know it sounds like a cliche in terms of the preparation, but it really is incredibly important, just getting that familiarity. And then it just comes with practice. It's not something that anybody is, naturally can walk in and just have the court eating out of the palm of their hand. This is definitely something that takes work and practice, and it comes with experience for sure.
Now, I don't know in Platnik if it was done in person or virtually, but I'm sure you've maybe had in the last year and a bit some experience doing things over Zoom or Teams or whatever the software is. And then that's also another wrinkle for these mooters, right? I mean, some of them may have competed in the past in person. And what have you noticed, or what can you maybe share with those doing it in terms of doing it on Zoom? Is it any different? Like, I mean, would you look at the computer the same way you would look at the court there? I mean, I guess it's a little, maybe it's a little more, maybe it's a little less. I don't know, in terms of, you would see like the little 9 boxes of the Supreme Court justices versus kind of scanning left to right in the room where they'd all be sitting around at the front. So maybe you can share from those experiences and any advice you can have for students that are going to go and do it on Zoom.
For sure. So I have I have appeared in front of 3 judge panels on Zoom, and I did appear in the Supreme Court on Zoom about 6 months ago or so. So I have appeared at the SEC on Zoom. Appearing at the SEC in person, 9 people is a lot of people. And so because I like to make eye contact, I was, over here and over here, and, you're sort of looking all across the room at the 9 justices staring down at you. It's a lot of people. 3 judges is a lot easier to manage than 9 in terms of making eye contact with each of them. But in terms of the shift then to Zoom, and I have done it for the moot, it'll be 3, correct? Yeah. So for 3, that's actually manageable on Zoom. So at the SEC, when I appeared, 7 of the 9 were in the courtroom and 2 were not in the courtroom. And but for all 3 appearances for all appearances I have done where there are 3 members, none of them have been together in the courtroom. They've all been separate. And for me, that's a lot easier because I can then set my screen on tiles so that I can see all 3 of the panel members as a tile. And as opposed to being on speaker view or some other form of view. But if you have it set to gallery view and you can see all 3 of the justices, then it's not that different than being in person, because you can engage individually with the 3 of them, and you can actually, they can't necessarily see you making eye contact with them in the same way. But if you're looking at the camera or close to the camera, then you can still be engaging with them. You can see their facial expressions. Again, you can see if they're looking down. So if they're writing notes, make sure, I'm sure the students have heard this, they need to speak slowly enough and need to hold for their next point. If the judges are taking notes, you don't want to start talking while the judges are writing. So if you've got it on tile view and you can see all 3 of them, you can see if they're looking down and taking notes. When they're looking back up again, then you can start talking again. But when I was at the SEC and there were 7 justices in the room together, the way the camera angles worked was that it was a wide angle. And so you could see all 7 in one shot, but they were too small in that frame to actually see anybody's face or see if they were taking notes. And I found that really disconcerting because I couldn't tell what their responses, what their facial expressions were doing. When they asked a question, then the camera would zoom in on them. And so if you were engaged with one justice asking a question, you could see them. But otherwise, 7 of the 9 were really too small for me to figure out what they were thinking at the time.
Yeah, and I think certainly as well, right, that even this, half the time I don't know where I'm really looking at because my camera's a little higher up.
Yes.
So it looks like I'm looking somewhere else, but it's because I'm not looking right at the camera there. So that's something also to pay attention to, especially if people are taking point form notes, as you had suggested there. Rather than writing out a whole script, it's pretty obvious whether you're on Zoom or in person. I guess it's a lot more obvious in person because you can actually see the papers. But if you're going to get creative, at least maybe put the papers somewhere where you're kind of in line with your camera, I would think.
So I still have it set up when I'm making submissions. I very much like to stand when I make submissions. I find it weird to be sitting. So when I'm making submissions on Zoom Court, I have a sit to stand desk. So I'll put my laptop with my camera up at the top, and then I have my lower level where I will have my my tablet with my notes on it. And I do have two other monitors on either side. And so I'll have my record on one side and my case law on the other side, so that I am still able to look at my two screens for my references. And then I will look down at my notes, but the judge can see that I'm sort of looking down at notes. And so it's very similar to how I would be standing and operating in a courtroom.
Yeah, it's interesting. I think you have a good setup there because you have all these things, and I think that gives you a little bit more of an advantage compared to sometimes you might not have enough room to kind of really spread things out. And certainly with the tablet, right? I mean, you can kind of quickly move through things rather than flip through a binder there. Yeah, how have you
I've
found
loved
that?
it. I love it. I love the technology. I'm thrilled to be paper free in court. I've done injunctions, I've done applications, I've done motions, I've appeared at the Supreme Court of Canada, and have never printed a single page for any of it. And our records are all electronic, the submissions are electronic, everything's done electronically now. And I mean, I have no paper in my office. I love it. It is so much better. It also allows complete flexibility to work other places. If I have to do something at night, at home, on the weekend, whatever, everything's on our server. It's all electronic, and I don't have to worry about, carrying home boxes and boxes and boxes of paper that I used to have to do in my early days of practice. So I am a huge fan of this electronic aspect of it. And I hope that that's one of the things that we are able to keep after COVID, because I really love the electronic aspect of it.
Now, I know you just touched on there before that, you would coach some law school mooting teams there. So maybe you can kind of, maybe if you have any kind of things to share for those mootings that we didn't maybe address in getting ready, especially, a number of them, it may be their first time competing. What have you told your students in getting them ready to go?
So as I said, a lot of it is the run-throughs are super important. The preparation and run-throughs, super, super, super important. The other thing that I suggest is ensuring that you do dress rehearsals in the space where you're going to be making the submissions, and wearing the clothes that you're going to be wearing when you make the submissions. So I don't know if these students wear gowns at all for their submissions, but the law school moot courts wear an outer gown over a suit. And so I always say they have to wear the outfits when they're making the submissions. It's like a dress rehearsal for a play. You have to wear the costume that you're going to be in so that you know what it feels like to be in that costume. You need to wear the shoe. If you're going to be standing, you have to wear the shoes that you're going to wear. So whatever the shoes are that you think you're going to wear, make sure that you wear those so that you know what it feels like to stand in those shoes when you're making your submissions. I think that's really important. And so even when I'm doing my run-throughs now, I will put on my court shoes and I'll put on my outer gown so that I am wearing the outfit that I will wear when I am in court. And I think that's super important. It's really, really hard to look at yourself when you've recorded yourself, but it can be helpful. So it's cringy and horrible and awful to record yourself and then play it back. But and I wouldn't recommend doing it at an early stage, because at that point you're still working out the kinks. But as you get to a later stage and you're almost ready to go, recording can often be a really useful tool as well.
Great. Thanks so much there for talking about the case and all those great tips there with respect to advocacy for those mooting. And hopefully they can take heart there and put their best efforts and achieve success later this month when they compete. Now, there are a couple of things I wanted to talk about, and we have a few minutes here. Certainly, I know you've done some really interesting social justice work, including some time in India there. Maybe you can talk to us a little bit about it. I know um, I believe you received, or even before that, a precedent setter award for your work in fighting for social justice. So congratulations on that. And maybe you could tell us a little bit about, a lot of my students want to get involved and do some social justice work. What are some of the things you did? And maybe you can tell us a little bit more about that experience in India.
So one of the things I love to talk about is how lawyers in private practice can introduce social justice and pro bono work into their practices. So I had a bizarre path to get to where I am now. I graduated law school, and then for 7 years between graduating law school, for the first 7 years after I graduated, I wasn't called in Ontario. I graduated law school, and then I did a bunch of international work. I did a program in South Africa. I did a program in Bolivia. Then I came back to Toronto, which is where I grew up, and I went to go work for the Canadian Civil Liberties Association. So I was actually a staff person at the CCLA for about 5 years. But that was without being called. So I worked for an NGO without being called. Then I decided that I really did want to get called. So I articled. I had to article 7 years after having graduated law school. Articled and then got called and I worked for two big firms, two big Bay Street firms. And at both of those firms, I found ways to incorporate social justice and pro bono work. And I would really encourage anyone who has an interest in that to seek that out from their firms when they're interviewing at the firms, ask about their pro bono policies, ask about what their opportunities are. There are lots of great opportunities for pro bono work when you're in big firms. And I'll come back to little firms as well. But when you're in big firms, a lot of the big firms do have pro bono policies, and they do encourage their lawyers to do pro bono work. It depends on the firm how much credit you may get for doing that work. And one of the things that I personally chose was I had done a lot of other volunteer work. I sat on boards. I did a lot of other volunteer work before I went into private practice. And I realized I just didn't have time to do everything anymore. I didn't have time to do some of the volunteer work that I had done before and do the pro bono work that I was doing through the law firm. So I made the decision that my volunteer work would shift and would become the pro bono work that I was doing through law. Volunteer work is super important, and it is incredibly valuable. I don't mean to discount it at all. But for me, I made the choice that there are only a certain number of lawyers that can go to the Supreme Court of Canada. And if I could do that, then that would be what I would do as my volunteer side. And so if you think of it not so much as what kind of credit will I get from the law firm, but this is what's important to me from a social justice perspective and my volunteer perspective, then it doesn't matter if the firm gives you credit or not. If they do, that's great. It's a bonus, but you're not dependent on it from the firm because you're looking at it from a different perspective. I also think it's important for pro bono and social justice work to look at it from your own perspective. Firms may think that doing social justice and pro bono work is valuable in and of itself, but they may not. And so one of the things you may want to look for is ways to pitch it to the firm that it's actually of benefit to the firm. So for example, if it's something that could benefit or tie into a client. So, if one of the clients of the firm has an aspect of social justice work or a corporate social responsibility policy or something like that, then pitch it as, these clients of the firm think that this organization is a valuable organization, so I'm going to go do work for that organization as well. Or, there's these clients have corporate social responsibility policies, and if we do this pro bono project, we can pitch it to that client that we've engaged in this corporate social event. So it's looking at it from the perspective of, yes, the firm may think that volunteer work and pro bono work in and of itself is valuable, but they may also look for something that's of benefit to the firm. And that's not a bad thing. It's just, you might have to find a way to pitch it to the firm as, here's how it benefits the firm as well as me. And then there's legal aid opportunities. There's all kinds of wonderful projects that you can do when you're at a big firm to do pro bono and social justice. And then there's firms that will prioritize pro bono and social justice. So now that I have my own firm, we do take on a fair amount of pro bono and social justice work. We can be creative in our fee structure. So we can do a deferred fee. We can do low bono. So it may not be a fully pro bono file, but I may charge the client a small amount compared to what my normal hourly rate might be. There's lots of ways that you can get creative in a small firm that may not be available to you at a big firm, but they might be. And it just depends on the firm that you choose.
Yeah, that's great. Certainly finding different ways to kind of give back while, possessing your law degree there. And certainly it's a while there that there was this 7 years where, people are rushing to write the bar exams and get called and do their articling. For me, I think it was about 3 years between the end of law school and 4 years, I think, after the articling itself. But I don't know if I've heard of anyone else with the 7-year gap. So, it's great that you've gone on and got your license there and are doing all this great work, advocating at the Supreme Court, amongst others, and all this great social justice work. I know that another thing there is that you teach at the U of T there at tort law, I think, for both the LLM and the JD program. Now, certainly for my students over the last year and a half, it's been a very interesting time. How was law school like in the, I don't know, I'm assuming it was Zoom. It could have been another platform. How did you find it as an instructor, with a group of 20-25 students? Do you see a bunch of black squares with names like I do, or how was it?
Yeah, so I teach in both the JD and the LLM program. In the JD program, it's a seminar, so it's a small group of people. But in the LLM program, some of them were pretty big. And I really encouraged my students to please turn their cameras on if they were able. I found it really hard to teach to just 1 or 2 students that had their cameras on. If the students were able to put their cameras on, and I had at least a significant number of them with their cameras on, and I could see their faces, that made it a lot easier for me to teach. But I also just have a huge amount of sympathy for students who did a year and a half on Zoom. The camaraderie aspect, the social aspect was completely missing for them, and my heart really goes out to the students, especially students who are finishing their degrees and their programs on Zoom. And that's, high school on. It's really tough to finish those huge events in your life on Zoom. And I really have a lot of sympathy for students that had to go through that. It was very hard for them.
I mean, I think it's just a whole different way, really. From being in person. Some schools I know would previously record things and stuff like that, but again, especially I think in your first year where you meet, your whole class, and you don't really get to meet, like an orientation. I know my students always joke, like every time I'm say, hey, I went to Osgood with this guest, and it's because we made those connections, in our first or maybe second year. But what in terms of maybe hopefully in September, we don't know yet, but maybe at U of T you do know, but kind of how to succeed there when you're kind of not getting the in-person experience, right? Where you feel maybe, certainly you can chat in the box there and ask questions, but what did you find kind of helped your students in studying via Zoom?
So I really encouraged my students, if they had questions. My teaching style is, again, very conversational, and I really encourage my students to participate, to ask questions, to engage on Zoom as much as possible. And I tried to make myself as available as I could to students after class, whether it was a call or another Zoom call, email, just to help, because I do feel that there is sometimes, it's harder, I think, to absorb the information on a screen than it is when you're in person. I did change my teaching style a little bit. I don't always do a full PowerPoint with the cases and the elements, but I did do that while I was on Zoom, just because I felt like that was easier for the students to have that information. So, if there's anything like that the students feel would be beneficial for them, I think they should talk to their administration about it and ask them. It was actually one of the things that the administration at U of T suggested, that, while you might not have done this in the past, we're finding that with Zoom teaching, it can really help the students if they have that information. So if the students have anything like that they think would help them, they really should be talking to their administration, because I know the administration, at least at U of T, is really trying to do everything it can to help accommodate the students during this time.
Perfect. So, Alexi, thank you so much for taking the time and joining us
My
here.
pleasure.
It was such a very enjoyable overview of all the different things we covered. Perhaps if you have any final words of wisdom there. I know you were just talking about students there, whether it's for mooters, whether it's for aspiring lawyers or anyone looking to get into the legal profession, of kind of making that, especially, I mean, I think the fact there that years later you went back and said, look, let me get my articling and my license, and anything you can share with them, because I know sometimes it's not necessarily by choice for some of the students that they may not necessarily pass an exam, or they may just decide maybe they're not into law, or they don't need it, and then there's no, I don't think there's a time requirement of getting the articling done, but who knows with the Law Society. But anything you want to share then for anyone listening, and thanks so much again for joining.
So what I would say, and I say this to people they're considering law school, but also for people who are in law school. I think the law degree is a wonderful, wonderful degree. And I know there's a lot of people who are, who give our profession a very hard time, even people in our profession who are very dismissive of our profession. But I really think the law degree is a wonderful degree. I personally have had pretty much 4 different careers out of my law degree. So I did international work right out of law school. Then I worked in Toronto for the CCLA. Then I went into private practice at a big firm. And now I run my own boutique. It's such a versatile degree. Whether you are being in private practice is a tiny part of what you can do with this degree. Lots of people are in private practice, and that is what a lot of people do with it, but it's only one option. You can be in-house, you can be in public law, you can be in government, you can do all sorts of things with a law degree. And I don't know of another 3-year program that's as versatile and gives you as many options as a law degree does. Whether you're called or not, or whether you're foreign trained or Canadian trained, there's just so many options that are available to people with a law degree. I just think it's a really wonderful degree from that perspective.
So again, thanks so much, Alexi, for joining us. I wish you all the best with your practice. And again, thanks for all the tips, especially on advocacy there before the Supreme Court. And take care and enjoy the shortened week there. We're all halfway done already, I guess. So take care.
Thank you so much for having me. Bye.